So, hello to everybody. I hope you're all doing well. So as you can see, today's webinar is the long view. We're very lucky to have Gordon Nardell, QC, from 20 Essex, and Sue Kim from HKA. Can I have the next slide? Come on, please. And this is their presentation. I have to say this presentation is amazing. It's immaculate in all its conception. And at the very end of the slides, there's a whole load of case law, which we won't have time to go through. But tomorrow you'll get a link where you can download this PowerPoint and all the other information. I would strongly recommend that you do so, because there's loads of information. And then, as I say, there's the case law at the end. Oh. Heckling on a Zoom. Right, so some quick housekeeping points before we begin. We use Zoom, but the meeting function. So this means that if you want, everyone can see your name and picture. And if you know, you can actually change your name. So you can change your name to whatever you like, but you can also put your name and your company or whatever else. This means that you can, hopefully you've had an opportunity to see who's here. Also a bit of networking after the webinar. And this is important to us because it reminds all of you that there are lots of other people out there. Yes, I know you haven't been allowed to see them, but they really are all there. And we do this because I think it's really important to encourage all of us to take a far more positive approach. So your video and audio transmission is switched on, but if you can just disable the sound during the talk, that would be great. You can keep the camera on. It's lovely to see as many of your faces as possible. I know some of you are obviously shy, and then there'll be those of you who've logged on, turned your camera off, and you're now doing something completely else. We've all done that. I did one yesterday. But, you know, be brave, put the camera on a bit. These webinars are meant to be more than just a learning process. It's the opportunity, I feel, for all of us to network and share experiences. And I hope that you actually enjoy these. We really welcome feedback, and we want this to be a positive two-way communication. It is a chance for communication and collaboration between all of you that are somehow involved in construction and engineering. So for those of you who are new to the webinars, my name is Bill Barton, and I'm one of the directors at Barton Legal. So I specialise in construction, and I'm now a Zoom webinar host extraordinaire. So to begin with, if we can, Cameron, can I have the next slide? Marvellous, thank you. So I'm going to introduce our first speaker, Gordon Nardell, a specialist in large-scale international litigation and arbitration, but especially in areas of energy, infrastructure, and utilities. Gordon started off his career in commercial litigation, but he soon got a taste for European and international cases and has served as a UK parliamentary counsel. In this vein, Gordon has served also as leader of the European Circuit of the Bar from July 12 to November 14, and was also chair of the Bar Council's EU Law Committee. So he played a leading role in the English Bar's intervention into the Brexit debate before and after the UK-EU referendum, overall advising on a broad range of Brexit-related issues. Unfortunately, he couldn't stop Brexit, clearly. Furthermore, he's a member of the Dutch Brussels Bar. He's got extensive experience of EU and public international law, and he's put that to a range of use in different sectors, as say utilities, telecoms, financial services. He's a fellow of the Chartered Institute of Arbitrators and an accredited mediator. Through 20 Essex, where he is now, he's also worked in Singapore, and he's on the arbitrators panel of various institutions, including the Asia International Arbitration Centre and the Shanghai International Arbitration Centre. Wouldn't mind a visit to those. So in summary, Gordon is an expert on disputes involving government bodies. He knows how public authorities tick and what they do and don't respond to. So he's not only a first-class advocate and lawyer, but he's an excellent strategist. So if your case needs a state-of-the-art battle plan executed with lethal effectiveness, I think Gordon is your man. And before this, I asked Gordon the thing that he's most enjoyed about lockdown. And he said that it was having his university student daughter at home with him over the last year. So I obviously asked him what he was most looking forward to after lockdown. And unsurprisingly, he said he was looking forward to the end of lockdown and his daughter going back to university. Next up, we have Sue Kim. I'm going to introduce Sue now as well because their talk is very interactive between the two of them. So Sue's worked across the UK, Europe, Asia, Australia and the Middle East on projects with values up to $18 billion and disputes in excess of $2.5 billion. She's a chartered quantity surveyor, UK trained, and also a qualified architectural engineer, South Korea trained. With 20 years of experience, you just wouldn't know it, would you? In the engineering and construction industries, acting as a court-appointed plus a single joint quantity surveying expert, you try saying that, and a party-appointed quantum expert in litigation, arbitration, adjudication, and mediation across rail, mining, and nuclear power. As I say, that is an impressive list. But she's also a fellow of the Royal Institution of Chartered Surveyors and Chartered Institute of Arbitrators. So as well as being an esteemed member of other organisations, Sue specialises in the evaluation of variations in dispute, disruption, prolongation, acceleration, and evaluation at termination. So she's worked with a whole range of standard and bespoke contracts. This immense level of experience is also supported by her academic excellence. She holds 6 degrees on the undergraduate and postgraduate level. I am in awe, and I would only ask, is now the time to mention that I went to a polytechnic? So I really am low down. So in summary, I think Sue is unique. She's dual qualified in several ways. She's bilingual and professionally qualified in Korea and the UK. She's been involved in major projects. She's a QS and recently admitted to the Bar of England and Wales. And she also tells me that she's incredibly funny with a great sense of humour. Anyway, I'm going to stop rambling. I'm going to pass you over to our presenters who will, so next slide, who will lead you through a truly, truly wonderful presentation. I hope you all enjoy.
Well, many thanks indeed, Bill, for those kind words and that warm introduction. But particular thanks to all those who've taken the time and trouble to log in, particularly those who've had to either get up early or stay up late. Excellent to see so much interest. And you know, Sue and I are aware that many of you are experts in your own right. So we look forward to hearing and seeing your own views on the topics we're going to cover. I've just displayed a slide showing roughly the roadmap to our talk. We're going to be flexible about this. We'll see how we're going for time. Some of these are points we'll just skate over. Some others we'll focus on. But broadly speaking, we're going to cover that range of issues. So next slide, and we'll kick off setting the scene. Construction contracts are about relationships, and the big difference between the kind of long-term projects that we want to focus on today and what I might describe as the more familiar, straightforward form of construction contract, it's the number and complexity of the relationships. So I brought up the difference on the slide, but let me describe some of the key differences because they really define the scope of our presentation. Well, first, the obvious one, and that it's in the title, it's the duration of the project. The construction phase in relation to a long-term project is really only the beginning. Something might take 2-3 years to build, but then it's going to be operated for perhaps 25, 30 years. So it's the duration of the relationship, and the parties have got to live with each other during that period. The nature of the work is very often different. We're talking generally about a public body, a state entity procuring a very large high value project. It might be a rail line, a fixed link, a tunnel. It might be we will discuss on Sunday. Might be Chloe, could I possibly just ask those who are attending to mute their mics for the moment, just so that we don't get any interference. Thanks very much. It's likely to be a large-scale project, and that informs the kind of physical problems you're going to encounter. So if you're building something very long and thin, like a railway line, the chances are you're going to have a ground conditions problem somewhere. along the project. The employer is usually a public authority, and that means you're going to have this overlay of regulation and governmental activity, including regulation of the project itself. In the case of the UK, the funding of the project is governed by the Treasury Green Book and value for money principles. And those don't only govern the inception of the project, they govern the entire life of the project. They govern the way disputes are managed, they govern termination and hand back at the end of the project. So the kind of legal issues that these projects throw up are also distinct from the more familiar form of contract. The relationship with the standard form of construction contracts that we're all familiar with is also interesting. If you look at the diagram on the left, all those arrows represent contractual obligations owed under construction contracts in the legal sense, usually in one or other of the standard forms. If you look at the diagram on the right, the construction contracts just over there, the black arrows over left bottom of the diagram. So the construction contract between the project company and the construction subcontractor, and most, if not all, of the construction subcontracts, to the subcontractors, will also be construction contracts. Everything else is a different kind of contract. In the case of the main project agreement between the authority and the project company, that will be a bespoke form of project contract. So it's not really a construction contract in itself. It's an agreement to procure the construction and long-term operation of a project. And the construction contracts, properly so-called, they're relegated to this corner of the field. So having introduced where the construction contracts sit in this, I'll hand over to Sue to say a little bit more about the relationship with the standard forms of construction contract.
Hi everyone, as you know, I'm Sue Kim. I hope you're all okay, safe and well. I do my best to keep within time allowed. And hopefully there will be time for you to ask questions later. And thank you very much for this opportunity to present. And there are PowerPoint slides here, and as I speak, they will come up for you to look at. Next slide, please. As for setting the scene, to start with, I'd like us to take a brief overview of construction contract. I'm sure many of you are very experienced in construction contract. And so if you already know some of the things I'm about to say, I'm really sorry if I bore you. So typically, large infrastructure projects have been procured under the EPC turnkey contract for lump sum price, where the contractor takes a single point of responsibility for the design, construction, timely completion, and cost of the project. But because of the high premium for a single point of responsibility under the EPC contract, EPCM, engineering, procurement, construction management procurement is increasingly common. In relation to the form of construction contracts, I've seen different standard forms of contract which are commonly used, most often FedEx Silver or Yellow Book, NEC, IKME, but less often PPC 2000. And as some of you may know, FedEx Silver is used for international process plant projects where price certainty and time is critical, and for projects designed by the contractor. Whereas FedEx Yellow Book is often used for offshore wind projects which are designed by the contractor. They're often heavily amended. For example, in the Middle East, the employers have their own standard form of contract which set up bespoke rules. Here I've given some examples of clauses that are heavily amended. The first point is the risk profile, which is the risk relating to cost, program, design, site, passed down to the contractor. The second point is in relation to the price. Clauses are often amended to include circumstances when a claim for additional cost can be made, because lenders prefer to have a price certainty, i.e. fixed price. The last point here is, most importantly, interface issues. So parties make sure performance risk is transferred between construction and operation contract. Next slide, please. Now, I'd like us to consider common causes of dispute. Next slide, please. In long-term contracts, construction risks remain a key concern in many countries, which often leads to high-value disputes and negative impacts on project timelines. We have here common causes of dispute during construction phase. At HKA, we've analyzed the actual problems encountered on more than 1,100 projects across 88 countries and published a report called the Crux. As you can see, change in scope of ongoing project is on top of the list, and also high on the list is contract misinterpretation, especially in bespoke or heavily amended standard form of contract. I'd like to emphasize here on this point that amending standard forms of contract, as you know, is a very risky thing to do. And interestingly, failures in administering contracts is no longer on the top of the list compared to, say, 5 years ago. So this reflects how contractors in many countries, including South Korea, have reinforced their contract management capabilities in recent years. And some have also improved governance and control systems. Now on the list here, but global disruption caused by the COVID-19 pandemic and continued payment delays as faced by contractors have also placed extreme pressures on contractors' margins. Next slide, please. This slide shows a comparison of common causes of dispute in different countries. And as you can see here, the principal causes of the construction conflicts are roughly consistent across the world. So the question is, to what extent each party bears the risks under the contract, and which risk is foreseeable at the time of the contract award? In long-term contracts, I find the employers very often passes off all construction risk, including interface, site contamination, and procurement risks to the contractors, who then pass those risks onto their supply chain. In my opinion, that is going to change. Next slide, please. I'll hand over to Gordon.
Many of the examples of categories of dispute that Sue has dealt with concern the construction phase. As I explained at the outset, that's the initial phase of one of these long-term contracts. What happens later on? There are a number of particular pinch points in the life of a long-term project where problems are particularly likely to arise. And one of them is that interface that Sue emphasized between the construction and operational contracts and the construction and operational phases. And one of the typical problems that arises in relation to this kind of project is what I call the stalled project problem. I'm afraid the photo illustrating this side is a peculiarly British cultural reference. Apologies to those who don't get it. Mr. Basil Fawlty giving his stalled car. If I remember rightly, it was a jolly good thrashing. So let's thrash out the legal issues in relation to a stalled project. What happens in relation to a project that's moving along the timeline? You build something, you start operating. When you finish building something, the contract will prescribe a series of tests. There'll be a readiness test, there'll be a completion test, then there'll be a commissioning test as the finished project, whether it's a waste facility or a rail link. You're testing the trains, you're testing the signalling, you're using, you're receiving sample test loads of waste, you're processing it. And it's only when those commissioning tests have been passed to the authority's satisfaction that the contract will move on into the services phase. And what happens if those tests aren't passed is that there's no handover to the operations phase. And then you get a number of issues which are likely to arise. The obvious one is, well, whose fault is it? Is it the project company's fault? Well, the likelihood is that the underlying difficulty, say, faulty design or execution of works, is a default by one or other of the underlying subcontractors. So you get this problem of default by the SPV, default by the contractor under the project company, being passed down a complex chain of contractual obligations and indemnities. So it's that complexity that tends to rear its head. Termination issues can rear their head at this stage too, but there's also a more subtle set of questions. And let me give you an example of one of them, this question of mismatching obligations. There are going to be certain contractual obligations that are appropriate at the construction stage that cease to be appropriate once you stop building something. And one good example would be obligations to maintain insurance. At the construction phase, the chances are the contractor is going to be bound to maintain CAR, contractors all risk insurance. That ceases to become apposite at all once you've moved into an operational phase. Then there'll be some other form of insurance you're bound to maintain, operations and material damage policy or operators all risk policy. What happens if you can't move on is that you have got a project which is complete in all physical respects. It's effectively an operational project, but you've still got an obligation to maintain car insurance. Now that sort of problem can be quite difficult, and it's the sort of thing that would be sensible to deal with careful drafting at the outset. But I've seen that sort of rather unexpected problem arise if a project stalls. At the services phase, well, this is really all about allocation of risk. As projects move on, the project itself outlives the financial base case and many of the financial and political assumptions that underlay the inception of the project. And so the question of how the risks of those changes are allocated between the parties under the contract becomes very important. There are bound to be changes in the cost of providing services. There are bound to be changes in the regulatory framework. There are bound to be changes in the political motivations of the authority. PFI projects were very, very popular in the early noughties in the UK, but they've since become considerably less popular, and many authorities simply want out. And this problem of one of the parties, usually the authority, wanting out for economic or political reasons, this is one of the characteristic problems of late stage or mid stage PFI contracts in the UK. And as we'll see, one of the difficulties arises when an authority that really wants out of the contract for political or economic reasons is casting around for contractor default. We'll see how problems arise when you try and shoehorn what's in reality a political or economic objection to the continuation of the contract into the provisions on contractor default. So they're the common causes of disputes at the interface stage and then the services phase. So next slide, please, and then over to Sue.
Now I'd like us to consider the third topic, claims procedure and tactics at the construction phase. Next slide, please. Our title includes how to avoid dispute. In my opinion, this is the most important topic that we all need to consider today, which is why I'm going to spend the longest time on it. I have 3 top recommendations here. First, better contract drafting. Second, being proactive right from the very start. Third, pushing for early engagement of all project stakeholders and deal with issues as they arise. And I have 2 examples where we can implement these recommendations. I call it claim procedures and tactics at construction stage. First, effective use of provisional sum. Second, condition precedent time bar. Next slide, please. So what is provisional sum? There's no formal definition, but basically this is a contingency sum. As Lord Justice May held the Midland Express case, it's a round figure guess. As you know, the provisional sum is the sum in the contract price to cover items of the works that could not be accurately defined, detailed, or valued at the time of the contract award. But the employer agrees to pay the contractor if the employer instructs the contractor to carry out the works once the scope of work becomes confirmed. There are 2 different types of provisional sums, defined or undefined provisional sums. So why do we have a provisional sum? This is some allowance in budget for the employers and programs for the contractor. It's a useful tool, especially where the design is incomplete or the contractor can't confirm its price at the time of the contract award. Standard forms of contracts such as JCT and FIDIC include provisional sum clauses, but on the NEC contract, instead of having references to provisional sum, changes are managed through risk registers, early warning notices, compensation events, and the contractor's assumptions to ensure the certainty of risks arising. In FIDIC contract, there's a provision allowing the engineer to require the contractors to submit quotations, and there are rules for valuation of provisional sums. But it's not general ground for extension of time, so the clauses are often amended here. Problems with the provisional sums are uncertainty, as you can expect, as to who takes the risk of time and price, and also there's some confusion about allowance for preliminaries, programs, and overhead and profit, depending on the type of provisional sums. So here, a clear contract drafting is key. For example, how provisional sums should be dealt with in clauses relating to instructions, variations, and effect of provisional sum work. Next slide, please. Next topic is condition precedent, the time bar. What is meant by condition precedent and a time bar clause? In construction contracts, condition precedent is a time bar provision in relation to entitlement to time and money claims and dispute resolution provisions. This remains a very controversial topic because some people regard these clauses as unfair and unreasonable. And if the claiming party fails to give a particular notices, strictly in accordance with the prescribed time period, it will invalidate the claim. But why do we have a time bar clause? It's a risk management tool. In the case of Multiplex Construction UK Limited, Mr. Justice Jackson held that such notice enables the matters to be investigated whilst they are still current. And it gives the employer the opportunity to withdraw instructions when the financial consequences become apparent. Both bespoke and standard forms of contract commonly include express procedures with time limits. Next slide, please. Both NEC and FIDIC contract expressly stated notice of a claim is a condition precedent. Interestingly, in Northern Ireland Housing Executive case, the Court of Appeal of Northern Ireland held that the time bar did not apply in circumstances where the employer should have notified the consultant of an event, but failed to do so. The court noted here that the time bar provision in clause 61.3 is an exclusion clause in favor of the employer and forced to be construed contra preferentum. I don't know about you, but I think that is a really correct decision. Next slide, please. The FIDIC 2017 suit is very prescriptive, now contains a number of detailed procedures that set out exactly what is expected of each of the parties and the consequences if they fail to comply with. So this FIDIC second edition contains 5 time bar clauses in relation to claims in dispute resolution process and 1 time bar in relation to amounts due in the final payment certificate. In relation to FIDIC Yellow Book, the TCC case here in Orascom is decide the point in respect of when the time for notice starts running. Next slide, please. There are key changes in FIDIC 2017 version, second edition. First of all, time bars apply to both parties, unlike the first edition, whereby clause 20.1 applies to contractors' claims only. And then the last point here that is set out circumstances when the claiming party can challenge in justifying late submission of notice of the claim. For example, the other party's prior knowledge of the event or circumstance, or the contractual or other legal basis of the claim. And again, I don't know if you agree, but I think such changes reflect the decision of the Northern Ireland Housing Executive case. And I think this is the right change. And perhaps we can talk about that later. Next slide, please, and I'll hand over to Gordon.
Thanks very much, Sue. I'm going to pick up the theme that Sue's just developed, notices as condition precedent in standard form construction agreements. And I'm going to look at how the courts have addressed that issue where notice provisions are contained in bespoke agreements, such as the head project contract between the SPV and the authority in a PFI type contract. Notice provisions come in all shapes and sizes, and the overriding health warning is it's a question of construction of each clause, but there are a number of trends which it's important to be aware of. Most clauses requiring the notice of a claim before a claim is submitted to litigation or arbitration require 3 things: a statement about the nature of the claim, the amount of the claim, which may be an estimate, and here's the problem area, the contractual basis for the claim. And all that information has to be contained in a notice that's given within the time stipulated in the clause. And the court's approach, certainly as far as the common law is concerned, is generally to treat any such notice provision, whether it's described expressly as a condition precedent or not, as a condition precedent. So if you don't serve your notice in time, or you served a notice in time that it was deficient, it didn't adequately state the nature, amount, or contractual basis of the claim, then you're barred from bringing a claim. And the trend in the common law outside the specific area of standard form construction contracts that Sue looked at is, I'm afraid, to favour certainty over fairness or flexibility. And I've cited a couple of decisions of the Court of Appeal, neither in England and Wales, Heritage, Oil and Gas, and TOCO and Aircom. Those are both claims under indemnities and warranties arising out of merger and acquisition agreements. They apply with equal force to head agreements in long-term projects, that the court is unlikely to rescue you. So if you want justice, don't choose English law as your governing law. If you want certainty, do choose it. And just to illustrate this in relation to a governing law of other common law jurisdictions, the Mida case against Bauer Hong Kong is very interesting. I noticed that we have an attendee from Mida, so I do hope I described this case accurately. This was one of those long-term project contracts for the construction of a fixed rail link between Hong Kong and Guangzhou. So one of those long and thin linear projects, you're bound to have ground condition problems somewhere, as I said at the beginning, and sure enough, they did. And inevitably there was difficulty excavating an area of rock, and that gave rise to a claim for variation and an extension of time under the head contract. And one of the subcontractors argued that they too should be able to claim a variation and an extension of time. And the question was whether the subcontractor had given adequate notice in accordance with the terms of the contract. It so happens that in this contract, there was a bespoke clause, but it resembled a clause based on the FIDIC 2017 suite. But the Hong Kong Court of Appeal took a very rigid view that the clause required the subcontractor to give notice, setting out the contractual basis of the claim, and what the subcontractor did was hedge its bets. It wasn't quite sure which way an arbitrator was eventually going to jump, and so it rather fudged the question of which provision of the contract the claim was made under. And the arbitrator was our very own Sir Vivian Ramsey QC, and he at paragraph 332 of his award said this: "I consider that both as a matter of sympathy and as a matter of construction, the contractual basis of the claim stated in the clause doesn't have to be the contractual basis on which the party in the end succeeds in an arbitration." So the party having to complete a notice within a very short time frame doesn't have to gaze into the crystal ball of what an arbitrator is going to be impressed by at the end of the day. So sympathy and tea from the former Mr. Justice Ramsey, I'm afraid rather less sympathy from the Hong Court of Appeal that said, no, sympathy out of the window. This is all about certainty. And what it said is the subcontractor has to give notice of the contractual basis of the claim, not any possible contractual basis, which may turn out not to be the correct basis. So hedging your bets, keeping your options open, can leave you without any option. And the simple message from this, I'm afraid, and I know it sounds self-serving, but it isn't for a very good reason, is if in doubt, consult your lawyers. Your lawyers are going to get a lot out of helping you draft a notice correctly than they are out of several months in the Hong Kong Court of Appeal. So it does pay to ensure that your notice is compliant and get a bit of help getting it right at the outset. Next slide, please. And over to Sue.
Now I'd like us to consider claims at handover and service stages. Next slide, please. I'll briefly deal with three issues here. The first, claim for late completion at construction stage. Delaying completion at construction stage will impact on revenue and profit generation and affect debt repayment. So completion risk should be carefully managed. As such, the contract may include a liquidated damages provision to ensure the construction works are complete on time and to specifications, or possibly award the contractor with a bonus for timely completion. I've seen many long-term contracts where practical completion is a defined term. My second point is defect performance of operation and services. The long-term contract often define a mechanism for dealing with the failure of special purpose vehicle, in shorthand SPV, to operate and maintain the facility and failure to meet up the output specifications. The first example of this mechanism is penalty points that will be awarded on each failure. So if SPV receives a certain number of points, it may result in no payment. It's a bit like a bad driver collecting enough points to be disqualified. And if all or part of the facility is now available to be used in the manner required, the authority is entitled to make deductions from the unitary charge based on the extent and duration of the unavailability. If there are major problems, once deductions have been made to the particular level, the authority can terminate the project agreement. And as Mr. Justice Cranston had in the Compass Group UK case, the purpose of the clauses permitting deductions for service failures is to provide a means by which the public body can ensure proper performance by the provider. So I think it may fall foul of the rule against penalties. The next slide, please. Lastly, at the end of the concession period, when SPV handovers the assets to public authority, how does one value those projects that have been historically problematic or poorly performed? There are a series of imponderables. For example, I've listed here problems due to financial issues such as cash flow, loss of profit, and problems due to patent or latent defects which impact on the future life cycle of the assets. All these have different impacts on the value of the project. So you need expert valuation. Do you need expert quantifying quantum expert, technical expert, and accounting expert? I think it'd be ideal to have those expert valuation in your hand. Next slide, please. And hand over to Gordon.
I'm going to pick up a very specific point, which Sue briefly alluded to, and that is the way the common law rule against penalties applies to a particular aspect of the pricing formula you'll commonly find in these long-term contracts. And that is the way the price the authority pays for the operational phase of the project, the way that that's computed. Now, I should just add that Mr. Justice Cranston's judgment in the Compass case was overturned by the Court of Appeal, but the Court of Appeal didn't overturn that basic statement that of the purpose of penalty provisions and clawbacks and so forth. And you'll find in most contracts of this sort two discrete kinds of provision that contain the possibility of clawbacks and penalties imposed by the authority. One is in relation to the classic situation where there's underperformance by the contractor, and that's priced into the contract. There can be deductions on notice, and as Sue says, if you pile up enough deductions, there may well be a provision entitling the authority to terminate. But deductions and clawbacks can also have a more subtle role. Many contracts for the operation of complex infrastructure, particularly in, say, the waste and utility sector, power plants, waste processing plants, will have an exceedingly complex series of pricing formulae. You know, the sort of thing that lawyers like me go into a cold sweat when we open the contract, and there are sort of pages and pages of something looking like that famous postcard of Einstein's blackboard at Cambridge. But essentially, the clawbacks or deductions are just part of a complex pricing mechanism. And that raises a very interesting question about the way those computations play in relation to the rule against penalties. Now, the rule against penalties is, of course, familiar in the construction contract context. The common law will treat as void and unenforceable a provision which prescribes consequences for breach, where those consequences, per the Supreme Court in the Cavendish Square case, are out of all proportion to the legitimate commercial interest which those clauses serve. So you have a provision which of a contract which provides an obligation. You have another provision, a secondary obligation, which tells you what happens in the event of a breach. Now, much ink has been spilled in the construction arena in the context of liquidated damages and how those play in relation to the rule against penalties. But you'll struggle to find any learning about how clawbacks and deductions, which are part of a pricing formula, play. I find it very difficult to find anything meaningful from the court on this, which is problematic because I've not only had to advise on this point, I've also had to arbitrate this point as an arbitrator in relation to a power plant under the law of an Asian jurisdiction. And it seems to me that what you've got to look at in that situation is what's the real purpose and intent of the provision. The Supreme Court made clear in the Cavendish Square case that the law against penalties only applies to these secondary obligations, a provision whose purpose is to prescribe the consequences of breach of a primary obligation. It doesn't have any application to a primary obligation, such as the basic definition of the services that have got to be provided and the basic definition of the consideration, the price that the authority has to pay for those services. So if a provision that's being complained about is fundamentally part of a complex pricing formula even though it may be in the form of a clawback or deduction. Indeed, it may be quite a swinging clawback or deduction in some of the contracts that we all know and love. That seems to me to be immune from the application of the law against penalties, because it's part of the primary obligations under the contract. It's not fundamentally a provision prescribing consequences of breach, even if a deduction that can be made in relation to the pricing formula could also bite on a breach of contract. So that doesn't allow the contractor to cherry pick bits of the pricing formula it doesn't like. Now, this doesn't work in quite as, I think that's probably the straightforward answer. It gets a bit more complicated when you're looking at how the law against penalty works in some of the codified contract acts that you find in some Asian jurisdictions. I'm thinking particularly of the Indian Contracts Act from the 19th century and the Malaysia Contracts Act 1950 that's based on it, where you have a codified penalty, but maybe a bit more difficult in those jurisdictions. If there's anyone on the webinar from one or two of those jurisdictions who has experience of dealing with those issues and the increasing gulf between the legislation there and the English Supreme Court in Cavendish Square in Al Maqdisi, I'd be very interested to hear from them. So that's the issue there. It's an under-examined issue, but a very important issue in relation to the operation of long-term contracts. Next slide, please. We're now going to deal with the biggie, which is termination. So on to the next slide, please. I'm just going to introduce these issues. Again, the health warning. Here's a photo of someone, a picture of someone who's terminated himself. I'm afraid I don't know about you, but I've been to far too many webinars where the slide on termination is adorned with a photograph of Arnold Schwarzenegger. So I thought I'd do things a bit differently. Inevitably, that health warning, the provisions about termination will differ subtly from contract to contract. It's all about the interpretation of the particular terms of the contract. But reducing it to its common bare essentials, I mean, the big difference in most contracts is between termination by the authority, and I'm putting a focus on termination by the authority for convenience, the authority simply wants out, and termination for contractor default. Well, if there are provisions for simply giving notice to terminate, why not exercise that right? Well, the answer is because it's very expensive. I mean, essentially, the financial provisions of the contract will require an authority that terminates for convenience to buy out the entire contract. And that means not only buying out the main project contract, but also buying out the subcontractors and, generally speaking, the lenders as well. That is not something an authority wants to do if it can avoid it. So if an authority wants out, it will seek, if it can, to terminate for contractor default. But that can be risky. The issue in the Compass case before Mr. Justice Cranston and the English Court of Appeal was an allegation by the contractor that it had received a whole series of notices of clawbacks and deductions. And it said the authority was just being excessive. It complained the authority was trying it on, and the authority was simply trying to pile on the defaults in order to clock up enough points to terminate. And there is a risk for an authority that seeks to shoehorn what's in reality a desire to terminate for political or economic reasons into contractor default provisions, and that is that if the authority gives notice of termination for contractor default, when in fact it hasn't substantiated a contractor default, then the authority risks itself being in repudiatory breach of the contract and having to pay large sums itself, including damages to the disappointed contractor. So the battleground areas which we're going to cover, and I'll hand over Sue to deal with some of these in a moment. First of all, proving contractor default. What are the key contractual terms and the facts and the evidence relied on? What are the authority obligations on seeking to exercise its right to terminate? And in particular, how does this strange beast, the idea of a common law duty of good faith that can sometimes be implied into long-term relational contracts, as the courts call them, how does that play? Can there be implied terms restraining the authority's freedom to exercise a right to terminate for contractor default? And we're also going to look at avoiding termination. We're going to look at some of those issues in the next chunk. But to look at some of the battleground areas, in particular proving contractor default, where that's what the authority relies on, I'm going to hand over now to Sue.
The next slide, please. As Gordon just mentioned, now I'd like us to consider proving contractor's default. Terminating a long-term contract, especially proving contractor's default, is far from straightforward. In long-term contracts, contractor default can be triggered by a failure to meet certain objective performance thresholds or by reaching particular levels of deductions made for unavailability or service default or a catch-all material breach provisions, whereby a sufficiently serious breach by SPV can give rise to a right to terminate. At construction stage, for example, FedEx Silver Book 2017, clause 15.2 details the 6 circumstances which give the employer the right to terminate the contract for contractor default. I've included the most contentious provisions in the slide here, but it's not enough to simply point to ground of termination. SPV may claim that the authority has repudiated contract. The consequences of wrongly terminating a contract can lead to substantial claims for damages. So the authority should prove the contractor default by identifying factual evidence which supports the ground for termination. Especially, it's really difficult to prove when the provision says, as in the Silver Book, without reasonable excuse, the contractor first proceed with the works. I've listed the relevant cases in the slide. For example, the second case here, Subic UK Petrochemicals UK, has a similar provision, such as failure to proceed regularly and diligently. It was held in this case, delay is not always a conclusive evidence of a lack of diligent progress. And the last 2 cases here, Hill case and Rickard's case, can be contrasted. In Hill, time was not of the essence. In Rickard's case, it was. Next slide, please. Now I'd like us to consider method of dispute resolution and avoidance. What methods are appropriate to long-term contract and how to resolve problems without collapse in mutual trust. So my first topic is avoiding termination. This is alternatives to termination when the contracts have gone all wrong. So termination may not offer the best value for money to the authority. So if an authority can't terminate its contract because of, for example, strong political support for the project, what else can it do to better its position? I've given some examples here, and I'll focus on the last point, lender's stepping right and innovation. Next slide, please. The lender's stepping rights under the direct agreement with the authority may be either permanent or temporary. It's temporary when lenders step in to rectify the problems which give rise to the authority's termination right. Here, the parties' rights and obligations under the relevant project document will be suspended until the lenders step out, at which point the original parties will pick up where they left off. And it's permanent when lenders novate the project agreement to a suitable substitute contractor. If the breach is not remedied by the lenders and their designated novatees, then it's likely that the authority will be able to continue with the termination. And because of the strength of the lender's positions, the parties' right to take any steps towards terminating the contract are subject to lender's consent. In the TS-ESC case, the giving of a prior notice of termination by the authority to a lender was a condition precedent to terminating a PFI project agreement. So when lenders receive such termination notice, they may be able to step in and take over SPV's rights and obligations under the project agreement. Next slide, please, and over to Gordon.
Thanks, Sue. I need to deal with a little bit of law, but then I'm going to look at what that tells us about the practical approach one needs to take to disputes, particularly where termination's on the table. How should parties conduct themselves where there are contract difficulties, where termination's on the cards? Well, the starting point is just to look at this interesting question. You know, if a lawyer describes a question as interesting, you're in trouble. But this interesting question of the common law duty of good faith, which I just mentioned earlier. And let me say a little bit more about it now. For a long time, English courts, common law courts throughout the world set their face against the idea of implying a general duty of good faith into contracts. Civil law systems have been much more comfortable with this idea for many years. So where are we now? Well, in a series of cases, the English courts have accepted that where you have a long-term relationship, the parties have got to live with each other for some time, that contract's described as a relational one, and the court will readily imply duties of good faith, and in particular a duty on a party not to exercise a contractual right arbitrarily, capriciously, in bad faith, irrationally, or for an improper purpose. So how does that play? Excuse me. How, more specifically, how's that played in the English courts in relation to long-term project contracts? Well, the Court of Appeal took a rather parsimonious view of good faith in this Compass case that we mentioned earlier. Mr. Justice Cranston took a rather generous view. He said, well, there's a provision of the contract that says that parties should negotiate in good faith in certain situations, and that informs their entire relationship. And the Court of Appeal, I'm afraid, were made of sterner stuff. And they said, well, if the parties have stipulated which particular contractual problems the duty to negotiate in good faith refers to, then they must be taken as deciding that they don't need to negotiate in good faith in relation to anything else. So no express duty of good faith. Did that mean you could imply a duty of good faith? Well, says the Court of Appeal, you can only imply a duty to exercise a contractual right in good faith if the exercise of the contractual right involves an assessment. If it's what the Court of Appeal described as an absolute contractual right, then the duty of good faith is entirely irrelevant. The contract is exhaustive as to the parties' rights and obligations. And what happened, as we've mentioned in the Compass case, is that the authority had issued a whole series of clawback and deduction notices, and they claimed that enough had clocked up to justify termination. And so the argument about bad faith was whether the authority, the argument about good faith was whether the authority was constrained to exercise its right to terminate the contract for accumulation of deductions in good faith. And the Court of Appeal said, no, it wasn't, but the provision about termination for accumulation of deductions itself contained provision about excess deductions. And the court found as a fact that the authority, the trust in that case, the Mid-Essex NHS Trust, had issued excessive deductions. So the two morals for the story. First of all, the moral of the story at the early stage when you're drafting the contract. Be very careful about defining what contractual difficulties the duty of good faith applies to. Is it general or does it apply to particular situations? Also be very specific where an authority insists on a power to terminate for cumulative defaults. Be very specific about what constitutes an excessive defaults or excessive deductions in that situation, because that may be the only protection the contractor has. Just very briefly about good faith. It seems to me that even if ultimately the court decides that a particular contractual right isn't constrained by a duty to exercise the right in good faith, the parties need to demonstrate that they're, as far as possible, they're acting in good faith. If there's a contractual difficulty, even if, and indeed especially if, you're the contractor and you think the authority is behaving like the trust in the Mid-Essex case, it's seeking to pile on the defaults with a view to constructing a justification for termination. As the contractor, it's very important to resist the temptation to retreat into the lager or fight fire with fire. On the contrary, it's very important to lay an audit trail demonstrating that as the contractor, you'll bend over backwards to try and meet the authority's concerns. Is there genuinely a problem of the design or operation of the facility? Is it a problem that can be passed down the chain to a subcontractor? Ultimately, can you talk to the lenders? As Sue has said, the lenders have a step-in right, but the lenders may very well be willing to have a word in the authority's ear because they have an acute interest in the fate of the contract. If ultimately there's a dispute, you may find that the lenders are willing to underwrite, say, the contractors, the project co's costs against a defaulting subcontractor, or even in certain situations, the project co's cost fighting out a termination issue against the authority. So explore your options, don't behave rashly, even if the court ultimately says that good faith doesn't apply. Bend over backwards to lay an audit trail to demonstrate that you've approached the issue in good faith as far as possible. I think we have one more short issue to handle. If there's time, Bill, it's just a minute each, if you'll indulge us.
Absolutely fine.
Over to Sue then, and the next slide, please.
Next slide, please. Finally, I'd like just to consider very briefly tiered dispute resolution clauses. Many long-term contracts contain tiered dispute resolution procedures, as listed in the slide here. In commercial contract, it's sometimes called lockstep clauses. So some of you may not be very familiar with expert determination, which is listed on the second point here, which is a snap contentious determination or used where the parties have agreed what should be decided and how. But the parties may later decide to put that determination within an overall mediation or negotiation structure to resolve all the issues between them. So our final thought, the first, these structured procedures encourage the parties to avoid the escalation of their disputes. So we should plan dispute resolution method in advance and work together with all involved, such as funders, stakeholders, advisors on both sides, to identify the critical issues that may arise and the best means of resolving them. And lastly, I've worked on various mega infrastructure projects in the UK and overseas, and based on my experience, if properly planned and managed, I find negotiation and mediation or standing dispute board can be very effective at resolving this dispute relating to the day-to-day operation of project, rather than resorting to more formal means of adversarial dispute resolution approaches. So it's a win-win for all the parties. I hope you found what I've said helpful and hope I haven't bored you. And I'll hand over to Gordon to deal with whether adjudication really works.
Thanks. Next slide, please. This is really a very short point. We're all familiar with, so sorry, just to go back one slide before I pick this up. It's just the last point. Does adjudication really work for complex non-construction issues? And actually, I'd pose this more of a question than a comment, but my paper, for what it's worth, you'll often find that where you have an operational phase of a contract, the parties borrow the dispute resolution machinery from the construction phase, which is almost invariably adjudication. Interestingly, construction contracts in the context of PFI benefit from an exemption in England and Wales to the 1996 Construction Act. But nevertheless, parties almost always contract back into adjudication. And if you're using adjudication for the construction phase, well, then why not maintain it for the operational phase? And I think my reflection on this would be that, well, adjudication was really part of the 1996 package to ensure that cash was released to subcontractors. It was never designed to deal with some of the existential questions that the interface stage and the operational phase of these long-term project contracts can throw up. And so do use it if you think it's helpful, but be cautious about using it for trying to resolve some of these very large questions that can arise. So the very last point from me, and next slide, and the last slide, penultimate slide, I think, if I may please. What's a bilateral investment treaty? Well, a bit of a minority sport, certainly in the construction field, but something that deserves slightly wider attention. A bilateral investment treaty is a treaty between two states under which each state agrees to guarantee certain legal protections to investors on its territory who are based in the other state, so a citizen of the other state or a company incorporated in the other state. And these come into their own, where a government counterparty to a project, particularly in a territory where the rule of law is fragile, where a government behaves badly and moves the goalposts in your project, and typically moves the goalposts in a way that makes it very hard for you to bring proceedings under the underlying contract, either because the rule of law is fragile and you can't use the domestic courts, or because the government uses its legislative power to change the law in a way that makes the commercial arbitration ineffective. In that situation, if a government has behaved grossly unfairly, think about whether there's a bilateral investment treaty between your state, the home state of incorporation of the contractor, and the state where your investment's taken place and where the government is allegedly misbehaving. Because the arbitration provisions under bilateral investment treaties can be very expensive and time-consuming to engage, but boy, do they work if nothing else works. And there have been, some of you were aware of this, a whole series of very high value awards against the Spanish government in favor of renewable investors who found the goalposts moved in relation to long-term investments that they've made in solar parks, construction operation of solar parks in Spain. So it can work, bit of a minority sport, but worth just having it at the back of your mind. And that, I think, is our last point. So thank you very much, everyone.
Thanks very much, Gordon. And Sue, if you all would like to click on your screens, you can change your view so you can have a gallery view of everybody speaking, everybody on view, sorry. What I would say is, if that isn't a perfect example of why you need to download slides, I don't know what is. I had the benefit of reading those before, but there is a huge amount of information in there. I strongly recommend you'll get the email, do download the slides. What we haven't shown you is there's several more pages of case law, with all the cases and summaries attached. Hopefully you will ask some questions now in the chat, and then I'll shut up, which is always a great benefit to you all. But I do have a couple of questions to kick it off for Sue and Gordon. I'll just say better drafting. God, music to my ears. Better drafting at the beginning, better drafting all the way through. I still review contracts where the drafting just isn't in plain English and with proper use of grammar and punctuation. I mean, you know, really, it's not difficult. So one of my questions is to either of Gordon or Sue, I mean, how predictable do you think some disputes are? And as the follow-on to that question, do you think that when parties are drafting and discussing contracts, they look too much at the now and they don't have enough forward thinking of what may occur?
Shall I have a first crack at that, if that's okay? Two reactions to that. The first is that from a drafting point of view, my advice is always make it as simple as possible. Don't simply rely slavishly on precedents. Think about what you want to achieve and say it in language that's as concise and plain and boring as possible. Try to avoid technical legal terms. Just use plain monosyllabic English if you can. It's much easier to have a disagreement about short, simple sentences than it is about very elaborate drafting. The other point is this: I think the practical side of this is that you have to remember that a lot of provisions in contracts are actually the result of compromises. The parties can't really agree. It's 2 o'clock in the morning. You're trying to reach close, and the parties just fudge and miss you. And in that situation, the parties are kicking the can down the road, and sometimes they know they're kicking it down the road, but it's just more important to close the deal than it is to close off every possibility. And the English courts, in some of their recent cases on contractual interpretation, have made exactly that point. These things are a compromise. The parties don't always have a common view of exactly what particular language in every clause is trying to achieve. So you can, for that reason, you can never tie down every potential area of dispute in contracts. But where you do anticipate a dispute, as I say, keep it as simple as you can.
Stu, have you got anything you'd like to add to that, or?
No, David.
Okay, the point I agree with Gordon. I think that I'd be interested to know who amongst the audience has ever actually had a workshop. In large contracts, what I encourage clients to do is I believe in a quite not aggressive, an interactive element of contract negotiation, because I think if parties discuss, argue, you actually get to understand truly what the clauses mean. But how many of you have experienced parties actually holding a workshop before a large contract? So parties actually then say, right, well, here's virtually the finished form. This is how it's going to operate in person. So how many of you experienced that? Just looking in the chat, does anyone have a question they'd like to put to Gordon or Sue? Because now's your time. You can all unmute and just first one who shouts, you're on. Nobody? You're all very shy. Okay.
I have one question from Indonesia. We have a contract where, written into the contract, there's a clause which says the contractor shall allow for all constructing the complete plant as per the owner's list, i.e. specified requirements. And it goes on to say that if we miss something off the list and it's deemed necessary for the safe and reliable operation of the plant, i.e. power plant, the contractor shall deem to have included it in his price. Would that be ever determined as a unfair term and condition in a project? Because we've got it here and it's causing them an almighty dispute right now.
And what's your governing law? Not Indonesian law, presumably.
I'm afraid so.
Well, I think an English lawyer has to be very bold indeed before trying to advise on Indonesian law. If your governing law was English law, I think the answer would be a fairly clear tough luck, because the courts take the view that they enforce the bargain the parties have made rather than the bargain the parties intended to make. Of course, what would be very interesting is whether that, under English law, is whether that's one of the situations where the court would say, it's a long-term contract, you imply a duty of good faith, and this is not an absolute contractual right, but an assessment has to be made by the employer about the necessity of a particular part of the project. But I don't want to hazard a guess about how Indonesian law would resolve that, I'm afraid.
Yeah, indeed. It's we have a Chinese contractor and an Indonesian government. So
what's your dispute resolution clause, out of interest?
It's there should be a DAB, but they failed to appoint, and it just goes straight to arbitration under Indonesian law.
And where's the seat of the arbitration? Is that Jakarta?
Jakarta, yes.
Yeah, interesting.
But it will never go because it's a Chinese-funded Indonesian government project, so they'll settle it amicably, and that's my purpose for being there.
Any more questions? Dusan said, in many cases, you do not have an opportunity to change the contract clauses. Okay, so Sue, Gordon, what's I presume there you're talking about the imbalance of parties' negotiating position. What do you two feel about that? Anybody, either of you got a view?
So I saw Sue was unmuted, so I thought.
Yeah, I mean, I've come across like this kind of contentions a lot, because people saying after the contract award, after the parties enter into contract, they argue whether there's such specific terms are unfair. But then, as Gordon mentioned earlier on, if the governing law is English law, we always take the view that, I mean, most likely take the view that both parties were free to agree the terms of the contract. So the terms included within the contract itself, we should all comply with. Therefore, we presented today, the three top recommendations we made today was, first one was better contract drafting.
Gordon, anything to add? Or?
Well, I think the answer to the specific question about international tenders is that you need to take a view about how to price risk and uncertainty into your bid, and of course the difficulty is if someone else is a bit of a chancer and is willing to take the risk, they'll underbid. But at least you're not then going to have a problem in 10 years' time that has a huge implication for the cost of performing the contract. So I think getting advice on the terms of the ITT and whether there are any nasties concealed in the drafting is probably getting some advice at that stage, so you can factor that into the pricing of your bid is probably where you need to go. It's, as you say, it's very difficult to try and sort out the problem afterwards when the court will simply say, if it's an English court, well, you didn't have to bid, did you? You knew what the terms were, that's what you've agreed.
Yes, and then I'd add to that in terms of thinking ahead. Some of the, I think Peter's and someone else has referenced solar projects. In the energy projects I've been involved with, one of the big problems has been takeover and acceptance tests and the staging or layering of damages, whether that's for takeover acceptance, availability and such like. And my experience is that people don't actually give enough consideration and thought as to what will happen if those are applied. And we as lawyers in the background are negotiating figures and prices, but that's sometimes not stepped down, if you like, to the engineers and looking at the true risks that take place. So within the drafting, I'd also say that communication needs to be, yes, as someone said, an early risk assessment. There needs to be more communication, collaboration between each party, their client and the engineers. My experience is that I would treat clients as finance director, only interested in cost, doesn't really care about performance, it's cost to build. Managing director, chairman, just wants a shiny thing, a woman, shiny thing to turn on and cut the ribbon. And then you've got engineers, and engineers come in various forms. Some will like beautiful, shiny equipment, Italian, some will want something that's more functional. But you have to get these parties to actually communicate and discuss. And that's what I see the role as a lawyer, to actually get your own client to do this communication and then translate to their language, because these people, in my experience, speak entirely different words and have entirely different meanings, even though they are your single entity client, and then translate that into a contract. And then you have to make sure the other side is doing the same job the other way. So that's where I see problems, because you don't get the translation in and you don't get the translation out of the terms. Who's got any other questions, either for Sue or Gordon, or who wants to? There's a huge amount of brain available here. People still signed on. So who's got a question for anybody on the call? Because now is your chance to ask a question of anybody, or just flag up a question that you would like the answer to, while I have a look through to see if there have been any other questions that haven't been answered. So over to one of you.
One more question from Indonesia. We have a situation where contractors apply for extension of time, and he's pushing the owner to make the decision. And we are hesitant to make a decision because he is concurrent with his own delays. I know that the protocol would say go ahead and award it if he's entitled to it, but we don't know the outcome of his own delays yet. Are we okay to wait and see the outcome of his own delays before awarding?
I presume that's aimed at Gordon or someone obviously vastly more intelligent than me.
No, that was aimed at Sue, actually.
Oh, it's Sue. There you go. There you go. Well, it's somebody vastly more intelligent than me.
I thought it was probably aimed at Sue as well.
All right. I think it depends. Again, it depends on the governing law as prescribed in the contract. I mean, as you mentioned, the protocol, SCI protocol talks about the concurrent delay position, which is a bit contentious. Like, if the governing law is English law, or whether the governing law is Indonesian law. But our first recommendation is again in line with our three of the recommendations we made. We have to be more proactive right from the very start. So I would recommend to make an assessment as you go along. Like, although you're not 100% sure about the extent of your delays or the other side delay, I would recommend to make an assessment as early as possible.
But not an award, an assessment and not an award.
Yeah, assessment from your side of assessment.
Yeah, it's assessment from the engineer's representative, which we've already done, and we hold, close to our heart. We're actually going to deliver to him tomorrow. But I don't want to recommend that the owner makes a recommendation of an award until such time as we know the actual end date of the contractor's own concurrent delay.
Yeah, in terms of concurrent delays, so it depends on the governing law and the express terms of the contract. So if you have further questions, I think I can deal with it if you just email me the further details. But you have to, the position of the concurrent delays is specific. I mean, subject to the express terms of the contract and also the governing law. So if I advise anything now, I have to include a heavy caveat.
This sounds like one for consideration off grid.
Yeah.
Okay, thank you.
The last page of our slides includes our contact details. So if you can just send me brief details of your positions, your situations, I can happily reply to give you some advice, if you don't mind.
Thank you very much.
It's interesting that Declan has put in the chat that he considers true concurrent delay to be as common as hen's teeth. So anybody willing to put up their hand and say they have come across an example of concurrent delay? Truly concurrent delay? No?
Obviously me.
Obviously you, obviously Graham, yes. But I have to say I'm always amazed that despite having a huge number of books and everything else, disputes are never quite in line with how they're meant to be. And I think, yes, existence of truly concurrent delay is very rare, but equally a dispute that clients say to me, well, you must have come across this before. Unfortunately, there's always a twist. Does anyone have any more questions you'd like to ask either Sue or Gordon or anybody else on the call?
May I ask one question, please?
Yeah.
Ali is speaking. Well, as of today, I see, especially starting with the pandemic, I see lending or taking grants more in say in execution. I mean, the grants are more in use. So how the parties will use those grants? So claims may come from granting part, actually, not from the contractors mainly, but how the grants can be used, because people are now trying to circulate the money and trying to create some jobs. Also, since we are here talking about long-term contracts, we need to take care about the environmental issues more and more. So, and also each and every time we are asking people, which type of contract are you familiar with? But actually, I think time comes somehow to find a common sense in all types of contracts to cope with the long-term issues, because all based on some common basics. So considering this granting obligations because of pandemic, because there is no circulation of anything at all much, and some environmental restrictions coming up very soon. So how do you see these type of contracts can be combined together or can be reduced according to regional maybe considerations or some cultural considerations on those needs? I mean, this is a quite general and quite, I mean, forensic question, but I think we are going to that sense somehow. I mean,
okay, so
it will not be sufficient, or only NEC will not be sufficient. So we need to combine them at all. How do you think about that? It's a general question. Who'd like to answer? Please go on.
I'll throw this open, but I would say that whoever mentioned hen's teeth, I think that the likelihood of all contracts having a common approach are zero, simply because if you look across FIDIC, JCT, ICHEM, you look at contracts in the Nordic states, how many of the clauses across all these contracts are the same? How many are the same in terms of termination that we've looked at? I think you have to look at, as Gordon and Sue said, you have to look at the specifics for your contract. I don't know, has anyone had any specific experience of, from what you're saying, sort of third-party external funding into a project and how that's impacted on well, presumably progress or otherwise, outside of force majeure? No?
You know,
Maybe-
I think COVID measures are so territory specific that it's very difficult to draw out any universal conclusions. But I did want to pick up, if I may, from Ali's contribution, the point about environmental considerations, especially climate change. And actually, I'm thinking about it. It's something I really ought to have mentioned earlier. That climate change is an absolutely enormous risk for these projects. And if you take a project, a 30-year project to build and operate a thermal power station, project inception 15, 20 years ago, long before the Paris Accords, most states now under enormous pressure to decarbonize their economy. So in that scenario, you have a long-term contract to construct the power station. It's being constructed. It's now being operated. The assumption was it was going to be dispatched when needed. A state that's worried about its carbon emissions is just going to stop dispatching your power station. Was that contemplated at the time of contracting? Does it give rise to a claim to damages? That's where you get into this rather interesting territory of international obligations under BITS versus international obligations under the Paris Accords. But that's the kind of, climate change is a huge area of risk. I mean, examples multiply for tripping over some of these long-term projects, particularly some of the pre-Paris Accord projects in the extractives, the utility, the power sector.
Okay, dokie. Right. Well, if nobody wants to take the opportunity of asking Sue and Gordon any more questions, which of course you ask the question and you're getting, as close as you possibly can to a bit of free advice. There's also, as I said, massive amount of intellect here. Just on this first page, I feel my brain being condensed, crushed by the weight. I'd really like to thank Sue and Gordon for speaking today. I hope you've all enjoyed it. I say again to you, you get the link tomorrow. Do click on that, download their presentation. There's so much information in there that they whiz through, lots of reading. If I can remind you that our next webinar will be on the 22nd of April. There you are. It's Hungry for Construction and How to Win at Adjudications. We have Dr. Gabriella Gallic from the KCG law firm in Budapest, and we have Kim Franklin QC from Crown Office Chambers telling us how to win adjudications. I
have to smirk though, because I've just lost an adjudication in front of Kim Franklin.
Oh, well, there you go, and that's just how good she is. I commend you all to sign up for that. You've also had through the chat details of, we do have a YouTube channel, my God, a YouTube, that you can download this presentation if you want to watch it again. You'll get the link for downloading the information. I hope you've enjoyed it all. Please do send us feedback on if you've enjoyed it. If there are topics you'd really like to see covered, please let me know. And also, if any of you would like to actually speak at one of the webinars, we're always looking for more speakers and people who'd like to contribute to our newsletters. It suddenly occurred to me, while I've still got a few of you left on, some blatant blatant request. I am still looking for a senior solicitor to join our firm. If anybody of you know a senior solicitor, construction trained would be great, but litigation, we can do tell them that we're looking for a senior solicitor, and because we're trying to grow. I hope you've all enjoyed it. Please tell other people about the webinar. And if you would, I'd stress again, if any of you want an introduction to anybody who's been on today's webinar, again, let me know. I'll happily make that introduction for you. We're not at all possessive of people who attend. So that's it, unless there's something else in the chat. Now I think you're all just saying thanks and goodbye. It's been brilliant seeing everybody today. I hope you have fantastic days. Those of you who've got up very early, then obviously you've got a long way to go. And those of you who are going to bed, sleep well. For everybody in between, it's been lovely seeing you all. Thanks very much, and we'll see you again soon. Take care. Bye.